Imagine this: a loving family gathered not to celebrate a joyous occasion, but to grapple with the sudden loss of their patriarch. Grief hangs heavy in the air, but it's soon compounded by confusion and anxiety. The patriarch, a man who loved his family dearly, had never gotten around to creating a will or trust. Now his family is left to navigate a complex and emotionally draining legal maze. Without a clear roadmap for his assets, the family's once unbreakable bond begins to fray. Disputes arise over cherished possessions, uncertainties cloud financial decisions, and the probate process drags on, adding financial strain to their emotional turmoil. This scenario, though fictionalized, reflects the harsh reality faced by countless families across America every single day. It underscores the critical importance of estate planning, a responsibility often relegated to the someday list, but one with profound and lasting consequences. Failing to plan for the inevitable can turn a time of mourning into a period of prolonged hardship. It's about ensuring that your wishes are honored, your assets are distributed according to your desires, and your loved ones are spared from unnecessary stress and conflict during an already difficult time. It's about taking control of your legacy and securing peace of mind for both yourself and your family. Let's demystify these crucial documents. A will, put simply, is your voice beyond the grave. It outlines how you want your assets, your house, car, savings, and other valuables to be distributed after your passing. It also allows you to name guardians for your minor children, ensuring their well-being in your absence. Without a will, the state steps in, dictating the distribution of your assets according to intestacy laws, which may not align with your wishes. A revocable living trust, on the other hand, is like a safe container for your assets. You manage these assets while you're alive, and upon your passing, they are distributed to your chosen beneficiaries according to your instructions outlined in the trust document. The key advantage: a trust avoids probate, the often lengthy and costly court process of validating and executing a will. This means your loved ones receive their inheritance faster and with less hassle. Think of it this way: a will ensures your final wishes are carried out, while a trust offers greater control and flexibility in managing and distributing your assets. Both are essential tools in securing your family's financial future and ensuring a smooth transition during a difficult time. The statistics paint a sobering picture. A 2023 study by Caring.com revealed that a staggering 67% of American adults don't have a will. This lack of preparedness can have significant consequences for families. Imagine your spouse, unfamiliar with managing finances, suddenly thrust into the role of navigating complex financial decisions while grappling with grief, or your children, unprepared for the inheritance they receive, making costly mistakes that could jeopardize their financial security. A will and a trust provide much-needed guidance and protection for your loved ones during a time of immense emotional vulnerability. They offer clear instructions on asset distribution, minimizing the potential for disputes and ensuring a smoother transition of wealth. These documents can also be tailored to specific needs, such as providing for a child with special needs or establishing charitable bequests. By taking the time to create these documents, you're not just planning for your passing, you're demonstrating love and care for your family. You're providing them with clarity, security, and peace of mind, allowing them to focus on healing and honoring your memory without the added burden of legal and financial uncertainty. Consider the story of John, a loving husband and father who tragically passed away in a car accident at the young age of 45. John, a successful entrepreneur, had built a comfortable life for his family, but he had never gotten around to creating a will or trust. His sudden passing left his wife, Sarah, in a state of shock and disbelief, compounded by the daunting task of managing their finances without his guidance. Because John died intestate, without a will, his assets were subject to probate, a process that dragged on for over a year. Legal fees ate into their savings, and Sarah was forced to make difficult financial decisions without her husband's input. The emotional toll was immense, adding unnecessary stress and uncertainty during an already challenging time. John's story is a stark reminder that tragedy can strike at any moment, regardless of age or health. It underscores the importance of being prepared, of having a plan in place to protect your loved ones and ensure your final wishes are honored. Don't wait for a life-altering event to spur you into action. Take control of your legacy today and spare your family from unnecessary hardship in the future.